Welcome to Arb You Listening, the podcast where we dive deep into the world of arbitration. This series is dedicated to bringing nuanced and diverse perspectives on arbitration to practitioners across the globe. Whether you're a seasoned counsel or just starting your journey in arbitration, this podcast will offer you valuable insights from top experts in the field, trained in various jurisdictions and legal systems. The podcast is an initiative of the India Arbitration Group of ICC India. My name is Aanchal Basur. I'm a counsel practicing in dispute resolution in India. And today we will be speaking about Procedural Order No. 1, which is issued at the outset of the proceedings. It's a document that sets the procedural framework that will guide the arbitration from start to finish. But why is it so important? You let our speakers and our moderator delve right into this. So today's esteemed guest speaker, and I thank her for joining us today, is Sapna Jhangiani KC. She's a leading figure in international arbitration with over 2 decades of experience resolving complex commercial disputes across Asia, Europe, and the Middle East. She has acted as counsel and arbitrator in over 100 arbitrations under all major institutional rules and is currently based in Singapore with Blackstone Chambers. She is also a part-time judge at the IFC courts and the vice chair of the ICC Commission on Arbitration. As the first woman in Singapore appointed as the King's Counsel in England, she's a true trailblazer in the field, and we are thrilled to have her on this podcast to share her journey and insights into the world of arbitration. I'd like to also introduce my co-moderator for this episode, Ms. Sudeshna Guha Roy. She's a seasoned disputes lawyer and a partner at Saraf and Partners in Mumbai. With over 20 years of experience, she's handled complex commercial litigation and international arbitration across top forums. She's also served as a sole arbitrator appointed by the MCIA in Bombay, and she's recognized by the Legal 500 as a recommended lawyer for dispute resolution. Thank you, Sudeshna, for joining us today, and I'm really thrilled to have this conversation. I think before we delve into all that is there to talk about Procedural Order 1, I'd like to open the floor to you, Sapna. If you can just tell us why we are having this conversation. This document is seemingly very innocuous. Why should practitioners be talking about it and why it's important, I think, just from a macro perspective?
Thank you, Aanchal. Thank you also for the very kind introduction. It's an absolute pleasure to be here. So, Procedural Order No. 1, I think I can't talk about Procedural Order No. 1 without putting it in the context of international arbitration generally. One of the reasons I really enjoy practicing in international arbitration is because it's a melting pot of cultures, of litigation cultures. You have cross-border disputes determined between parties from all over the world, and there is very little prescription about what the procedure should entail, and that's deliberate because when you have a cross-border dispute, you want to make sure that you can choose and tailor a procedure which is appropriate to the dispute at hand. But of course, we couldn't start from scratch with every single arbitration, and we really have to find a balance between tailoring the procedure to the dispute at hand and also having best practices and standard provisions that we tend to include to make sure that the arbitration is administered properly. So I think we always have this tension between having some harmonization and standardization, but also having some flexibility in the process, because that's one of the great beauties of having international arbitration to decide international disputes. And I think that when we talk about Procedural Order No. 1, one of the debates that we often have is that every arbitrator will have a standard Procedural Order No. 1. And what happens is when you roll out your standard Procedural Order No. 1, which of course it's very helpful to have, I have one, all the arbitrators I know have one. When you roll it out, there is a danger that you're prescribing what the procedure should be and not giving enough thought to how the procedure might be tailored to the particular dispute at hand. So I think we straddle this tension as a community, and I think that we each straddle it individually. And there are different ways that you can seek to resolve that tension. Just one thing I'll say at the outset is you had mentioned when inviting me to speak today that it might be useful to have some tips for junior arbitrators. And I think that for those who are less experienced and still building their skills as arbitrators, it can be incredibly useful to have a good standard procedural order number one to make sure that you have parameters in place to ensure that the procedure is fair, that it's efficient, and that you're meeting all the major milestones that you would need in an international arbitration. I think, however, as you get more senior as an arbitrator, I think it's incumbent on those of us who've had the privilege of arbitrating for a while to try and make sure that we are having discussions with parties about what an appropriate procedure might be. And really, that discussion has to take place at the first case management conference. Procedural order number one should be the result of that case management conference, but having a standard procedural order number one shouldn't be a substitute for having really important discussions with the parties about what the procedure might look like and what views and input they may have on an appropriate procedure.
Yes, exactly. And I think I'm going to take you up on this little later as to what those real elements are in, making your standard procedural order. But Sudeshna, if you can come in here and, I know that you had some talking points on what's happening in India on procedural orders and why we really need Sapna's views on how to deal with this situation. So if you can just come in and tell us, your talking points on this.
Thank you. It's a great privilege to be here and to be actually speaking on the same panel with Sapna, somebody whom I admire greatly. And I mean, it's always great to have women breaking barriers at all levels and, to have somebody charter the road before you, it's always a great inspiration. Having said that, in terms of procedural orders, there's a slight problem in terms of, I won't say it is a problem, but like Sapna said, that we grapple with certain issues. And I think that issues in terms of Indian ad hoc arbitration is much more significant than in terms of institutional arbitration. Because the institutional arbitrations, the rules are much more sophisticated. And to that extent, they have exactly what Sapna said, a reference point or a standardization of what a first procedural order should be, because it represents the first substantive engagement with the parties after the tribunal is constituted, and it kind of sets forth the procedural roadmap for the entire arbitration. While it sets the procedural roadmap, it's very important to understand the nature of the dispute and what it entails, because a construction arbitration would have very different from a shareholders dispute, and therefore the procedural order needs kind of that much of tweaking and needs to reflect the understanding of the dispute and how the dispute as it evolves would entail. What problem in terms of, or the issues plaguing the Indian ad hoc arbitration as of right now is, the Indian ad hoc arbitration is still a large part of the domestic arbitration. And you have arbitrators who are mostly retired judges of the High Court and Supreme Court. Because Section 19 of the Indian Domestic Act kind of makes it a completely party-driven, gives it the autonomy to the parties, as it should be. And there is no standard reference point for the first procedural order. And that is why there is no uniformity. The minute you go to an institutional arbitration, there's still an amount of uniformity, and then you kind of tailor it in terms of the dispute. And that is why I think that in terms of the Indian context and ad hoc arbitration, the PO1 kind of assumes great significance, especially in light of the fact that today we have a bill pending. And if we could have some sort of a reference point or some sort of a pro forma or a guidelines that what a procedural order should entail, would actually benefit ad hoc arbitration greatly in India. Because at least for the next 5 to 10 years, it's not that, even there's slowly people are shifting to institutional arbitration. Ad hoc arbitration is not going to go away. So if it's not going to go away, we need to have some sort of a uniformity there.
Absolutely. And I think that's the reason for this podcast. So I'm just going to ask you a question, Sapna. And I think a lot of our listeners, when they go for an arbitration, so typically in India, just to give you perspective, the first hearing is essentially never a case management hearing. So what happens in the first hearing is an exchange of pleasantries. And then, they give us a blanket 4 weeks to file our statement of claim. And then the arbitrators decide to meet for an additional time or whatever for the next hearing once the statement has been filed. So essentially, there is no roadmap setting. And it is something that a lot of practitioners have really not seen or been exposed to. So my question to you in terms of your experience is this, Sudeshna did mention it. So in terms of different arbitrations having different procedural orders, is that something that you also followed? You have separate standards for separate kinds of arbitrations? Or is it something that you sort of just take it in your stride and you see mostly on parties and not actually the case at hand or the issues at it?
Excellent. So I do have a standard and I also have add-ons. I have a confidentiality add-on which can be incorporated. I have a data provision add-on which can be particularly important for parties in certain areas of the world. I've now got a small provision addressing AI because increasingly arbitrators want to use AI, parties want to use AI, and I think it's important that we have some safeguards included. And really that's one of the important points about Procedural Order No. 1, which is exactly the same point that Sudeshna made, that in an ad hoc arbitration, you need this roadmap and you need these procedural safeguards. And I think even in an institutional arbitration, because the rules tend to be quite bare in terms of what the procedure is, I can't tell you the number of times that an issue has cropped up in an arbitration and I've gone back to look at Procedural Order No. 1 and thought, oh, goodness, thank goodness that I included that provision because it's actually very useful now. So even though there can be some criticism of arbitrators for having very long and very detailed standard forms of Procedural Order No. 1, which they are willing to tweak and to discuss with the parties, actually having these parameters set out in quite a lot of detail can be incredibly useful. Before today's session, I pulled up a Procedural Order No. 1 in one of my recent cases, which has just started. And I was looking at it just to be able to share with you the kind of things that are usually covered. And you have things like powers of the tribunal. You may have powers of the tribunal addressed in the applicable institutional rules, or you may have an ad hoc arbitration, but it can be quite useful to have more information and more flesh on the bones about precisely what those powers may be. In this particular draft procedural order, there's a section on exclusion of liability, which can be a real issue in certain jurisdictions in Asia. We hear about arbitrators being sued. There's a provision on service of documents. There's a provision on the hearing. There's a provision about a list of issues, which I think can be very important in an arbitration. So we tend to have quite comprehensive standard Procedural Order No. 1s. They can be tweaked according to to tailor to the dispute at hand, but I think a lot of these provisions are quite important. And the final point I'll make just on this is that the procedural order can be used as a tool to shape how specific parts of the procedure will play out. What do I mean by that? In this particular procedural order that I'm looking at, it's got very detailed provisions on document production. For many of us in international arbitration, document production has really become, or certainly for arbitrators, I don't know about counsel, but it's become the bane of an arbitration. We see redfern schedules pop into our inboxes and we're sort of, dreading opening them and seeing how many document production requests there are. And actually, if you look at the IBA guidelines on the taking of evidence, which address document production and frankly have been incorporated or adopted in every arbitration I've been involved in the last 10 years or so, whether as a loose guide for the tribunal or something that the tribunal is bound to follow. If you look at those guidelines, they actually include a provision that the parties may discuss their document production requests and objections and seek to narrow the issues in dispute. But I don't think this is being used enough. So what we've done in this procedural order number 1 that I've pulled up and I'm looking at is really flesh out, well, what will that look like? You issue your requests, you issue the objections, you have a discussion, you try and narrow, so you can really shape the procedure and deal with aspects of the procedure that can be quite challenging or can become bottlenecks in an arbitration.
Very interesting. What kind of arbitration is this that are you already anticipating a lot of document exchange requests? Are you anticipating multiple redfern schedules? It's interesting to see that, you've sort of taken that one step further from the IBA guidelines and sort of narrowed it down further. Why has this happened?
Aanchal, it's experience. Doing more and more cases as arbitrator, seeing more and more difficulties with document production, copious document requests, long redfern schedules, and thinking there's got to be a better way, and really trying to do a cost-benefit analysis of all the time, effort, and money that is poured into the document production request process, and what actually is the outcome in terms of relevant material documents, and thinking, well, there's got to be a better way. So it's really experimenting, and that's the beauty of international arbitration. We have so much flexibility in the procedure, but I think we've got to keep pushing the envelope, trying to do better, and that incorporate better practices. And that could be one of the reasons why we have so many arbitration conferences, because we want to have opportunities to discuss and compare practices and how they are working and experimenting with new innovations. So I will let you know how that goes.
That's very interesting. And that I think brings me to my next question. Unless, Sudeshna, you have something to chip in on this.
Yeah, I think I'm completely aligned with what Sapna said. See, in terms of a procedural order, like she said, that the power of the tribunal, which is basically what we refer to as the jurisdictional confirmation, because a lot of time you see, especially in the Indian context, application challenging the jurisdiction on issues which are far beyond the ambit of Section 16 under the Domestic Act. So something like that would always, help. And confidentiality issue, not only that, the communication protocols and how it would be an effective or an accepted mode of service, and the document management. I mean, I cannot stress enough, and Sapna has actually elucidated the problem that the redfern schedule has actually become not only a bane of arbitration, international commercial arbitration, even in domestic arbitration. See, one party is always wants to delay the matter, which is completely antithetical to the entire procedural efficacy and a speedy dispute resolution. And redfern is playing into the hands of those people. So an efficient arbitrator who understands the scope of the arbitration and who understands what are the issues involved to that extent, but sometimes the redfern schedule, I've seen it being exploited so much that I actually look forward to these conferences to people say, and especially people being as arbitrator like Sapna in so many diverse kind of arbitration, how you were dealing with it. Because more often than not, I am the opposing counsel in an opposing party, and I'm thinking, you've given me some 200 documents, out of it 150 has no relevance. You just want to drag out the procedure. And of course, but in India, I mean, like again, in ad hoc arbitration, what is happening, judges who have retired as commercial court judges, because like I said, Section 19 is a very bare-bone provision in terms of procedure. There's no reference point as such. But Commercial Courts Act, otherwise in India, kind of is a very, very detailed provision about case management theory. In the Commercial Act, it came to kind of speedy resolution of commercial court cases, right? They amended our CPC. I have seen actually some of these judges emulate the Commercial Act case management, as in kind of put in those things, because the more robust it is, the more likely you're going to debase your
To see. In fact, you're absolutely right. Because there is no standardization and because there is no exposure on how these procedural orders need to be drafted, a lot of people use, I'm sure there are CIR guidelines, etc., that are also available on this, but just tailoring their first procedural order on the local CMC statute is also something that we are seeing, which is very interesting, which means that they want to get things tailored in the beginning, but are looking for some sort of a direction. Sapna, on this, I have another question for you. So, as counsel, um, yes, we have spoken about, the procedural order, and of course, experienced arbitrators already have a standard form prepared. They will know what points they need to discuss. How do we, as counsel, prep for the first procedural hearing? As an arbitrator, what do you expect your counsel to, how do they walk into the room, prep with the case, and what really would, benefit their position in the proceedings?
Well, there's a couple of points here. I have been involved in arbitrations where counsel have put forward a draft model procedural order number 1. It was the claimant who drafted it and proposed it to the respondent, and then it was put forward to the tribunal as a proposed agreed draft. I thought that was tremendously helpful. And actually, in that particular case, it was an arbitration seated in London. And in London, just before that, there had been a new practice direction introduced in the commercial courts about witness statements, which had really become very long pieces of advocacy, which I think we see in many jurisdictions. And I think that commercial court judges were getting exasperated by these very long pieces of narrative that had no connection with the witness's recollection. And so elements from that practice direction were incorporated into procedural order number 1, which I think is a very interesting example of how we see best practices in litigation in different jurisdictions find their way into a model procedural order number 1 for arbitration. It's all about trying new things and seeing what works. And I think if the parties hadn't proposed that model procedural order number 1, the tribunal may not have thought of having these new provisions on witness statements. And so I think parties can propose a model procedural order number 1 for a particular case. I'm certainly very open to that as arbitrator. At the end of the day, it is the parties' arbitration. And if they want a particular procedure, that's something that I think we need to take very seriously. But I think it's quite unusual for parties to propose procedural order number 1. I think the usual process is that the tribunal propose it, and then it's discussed at the case management conference. And I think it can be quite difficult for counsel. Let's say I have a 20-page draft procedural order number 1. I'm saying 20 pages because I'm looking at the one that I just pulled up, which is quite a long, detailed document. If I'm going to an arbitration and I'm going to be prepared to raise comments on aspects of procedural order number 1, I'm going to pick my battles. Some procedural number 1s will tell you that, you need to submit your submissions in paper, this A4 size and not this size. I mean, mostly we have soft copies nowadays, but I've seen very, very prescriptive procedural order number 1 saying where they should be hole punched, etc. And you're probably not going to raise an objection on that. But I think it's one of the challenges we have with a tribunal presenting a draft procedural order number 1. There may be many aspects of the procedure as counsel that I think should be changed, but I'm going to pick my battle and probably just stick to the most important ones. But I think that does illustrate one of the dangers with pre-populating procedural order number 1 and sending it to the parties. What I do in quite a few cases is actually ask questions to the parties have the discussion at case management conference number 1, and then send a draft procedural order number 1 to the parties. I think you're much more likely to get more input from counsel as to how they want to shape the procedure than if you present a draft procedural order number 1. So I just present that to you as different options as an arbitrator. As counsel, I think you need to go to your case management conference number 1, prepared to comment on the procedure. Don't be shy about suggesting a different way of doing things. That's, as I say, we have flexibility in arbitration procedure. It's your right to make proposals, and the tribunal should consider and take seriously what you propose and consider, subject to the other party's views, whether it's appropriate or not. The other thing that can be incredibly helpful for counsel to do, not just for procedural order number 1 or case management conference number 1, but frankly throughout the arbitration, is cooperate with the opposing party's counsel.
Relevant, yes.
And the ways you can do that is by, let's say you receive draft procedural order number 1, start liaising with your counterparty's counsel as to what an appropriate procedural timetable may be. Quite often, tribunals will propose all the milestones and then leave the parties to liaise to fill in the actual dates. Again, I try and be open depending on the case. It might be interesting for the parties to liaise, to suggest what the procedure may look like and what the specific milestones may be. They may not want document production. It's rare, but it's possible. So I think being cooperative and taking the opportunity to liaise with your counterpart about procedural matters in relation to procedural order number 1 and generally will be very welcomed by any tribunal.
Yes, absolutely. I think that's pretty fair. Just on that, Sudeshna, I know you have a point, but I'm just going to stop right there. Add a little tidbit of my own on, on a matter that we were doing where the arbitrator was very creative, and we had a fairly long procedural order. It was under an institutional rule, the Singapore International, the SIC rules. But what the tribunal actually did not keep in mind is that the other side, the other party was a Nepalese party. So the procedural order also had aspects like the translated documents should be in this particular format and should be, certified by this particular, authority, etc. What that ended up doing was in Nepal, you can have multiple translations of the same document authorized by the same notary. So what that ended up doing was that the counsel were just exchanging translations which said different things of the same document. And it became absolutely quite a mess to deal with, then those documents and to look at the evidentiary stage. So I think what primarily I also want to ask you is that maybe in cross-border disputes, is this something that you also try to avoid overpopulating the PO in terms of, applicable law or governing law of dispute? Is this something that is a concern to you when you're looking at two different parties from different countries?
I mean, listen, I think counsel have a very important role to play if, as we've mentioned before, procedural order number 1 could be very important as a roadmap for the arbitration, but also containing procedural safeguards for the arbitration. If I'm counsel for a claimant, I want to make sure that I've got a good enforceable award at the end of it. And so does the tribunal. So I think you need to raise any points that are going to be problems throughout the arbitration. One example is if you're counsel for the claimant and you've got a non-participating respondent, you'll want to make sure that procedural order number 1 sets out how the non-participating party has been served. In certain jurisdictions, you'll need to prove service in certain ways. That would be a shared concern and interest with the tribunal, who also wants to make sure that there's good, proper, locally acceptable evidence of efforts made to serve all documents on the respondent. So I think counsel have a role to play, the tribunal has a role to play. You have to think about what particular issues may crop up in this arbitration because of the nature of it, the nature of the parties, and perhaps thinking about the likely jurisdictions for enforcement as well. So I'll give you another example. In the UAE, it's a tradition that arbitration awards are signed on every page. I'm not sure if it's still a necessity for enforcement of an arbitration award, but if you want to make sure you have an enforceable award, you may as well cross your T's and dot your I's and try and ensure that that's done. So these things that you can think about, I think counsel can play an important role, just as important as the tribunal, in making sure that specific procedural safeguards are included.
Right. Sudeshna, sorry, you had to
No, I completely agree. See, the entire procedural orders, when as a counsel, when I step in, and my approach generally towards an Indian ad hoc arbitration is very different from an institutional arbitration, whether it is seated outside India or like a SIAC arbitration seated in India. Because I've seen that the party, in my experience, the opposing counsels or the opposing party stance in both these kind of arbitrations are vastly different. What Sapna was talking about, collaborating with the other side in the process of a draft order, parties are more and more open to it. I've seen in international commercial arbitration. But in domestic seated arbitration, there's a certain amount of rigidity. I mean, everybody thinks that, it's my way or the highway. So particularly in terms of domestic seated ad hoc arbitration, I go in terms of the draft order which I am thinking in my mind are generally in terms of including one important thing which I always generally put it out in case when the tribunal or the sole arbitrator is dictating an award, the first procedural order we're talking about is include provisions for allowing modification on timetables upon justified request. Because I have seen in my experience in most of the domestic arbitration which is seated in India, the timetables are taken very, very lightly. So as a party, whilst I would want to follow it, I always want to give that kind of a flexibility in terms of a justified request so that there's a sufficient cause for delay and put that checks and balances. A lot of time you have, because in India what happens, the clock for the arbitration lifespan starts after you've completed the pleadings. And if that bleeding takes an inordinate amount of time, and a lot of time the tribunal just gives that additional 3 weeks, 4 weeks without, them making out a case. That is something I always look for, putting that check and balances in terms of as a counsel, and also kind of, identifying those procedural elements that require clarification at the outset, like aligning parties' stance on the seat and applicable law, if that is not already agreed upon, because those things actually can become really, really contested things later on, So, and also that identifying those areas of procedural agreement before the case management conference to streamline discussions. I think as a counsel, therefore, I would say my approach towards domestic arbitration before an ad hoc arbitrator and before an international commercial arbitration is slightly different depending on the the parties.
Absolutely. I'm even surprised that you're speaking to the other counsel and checking on timeline in a domestic arbitration. I'm frankly surprised. But that's the way we do it here in terms of adopting great guerrilla tactics to make sure that the other side doesn't get their way. And it's interesting. So next time I have a bad opposing counsel, I'm going to call Sudeshna. You there's to try cooperate, yeah. It's just like great. Sapna, just last few pointers before we let you go in the last second.
Can I add on just one point? Just really to comment on where we've reached. I think that we all have a consensus that actually we need certain standard things in procedural order number 1. And in certain jurisdictions where we're still building a foundation of what the procedure of an arbitration should look like, to the extent it will be different from litigation, it's even more important than it might be otherwise. But I think what we've also discussed is that it is important to always have a mind to particular issues that may arise, particular enforcement issues, and then adding on some tweaking and some tailoring. Just one point further I want to mention. The more experienced you get as an arbitrator, the more that issues may occur to you that really warrant discussion at the initial case management conference, and then warrant being addressed in Procedural Order Number 1. I'll give you one example. To those of us who are common law qualified, we're very familiar with the rule in Brown and Dunn. But if I have a Vietnamese party and an Indian party appearing before me, it's very possible the Vietnamese party civil lawyers may have no idea about the rule in Brown and Dunn. And there may be an assumption from the common law lawyers that they have to put their whole case to the witnesses, even though it's arbitration and not litigation, depending on what the seat is. But in many jurisdictions, rules of evidence and litigation won't apply. So you might want to raise at the first CMC, by the way, there is this rule in the common law, but we're in arbitration. Do we really need this? What you can do is you can raise issues and avoid misunderstandings later. Another area is preparing of witnesses. The approach in the US is going to be very different from the approach in common law. I think in the US, you'd be accused of negligence if you didn't actually coach your witnesses to give evidence and actually run them through a mock cross-examination based on the actual facts of the case. In England, we cannot do that. It's against our professional obligations. But you might want to think, if you have witnesses and you have US lawyers and the US party involved, whether you need to discuss this at the case management conference and find a way to level the playing field if that's possible. But I think there's a great opportunity in Case Management Conference 1 and Procedural Order Number 1 to try and find these cultural mismatches and see if you can discuss them, ventilate them, and address them if possible.
Right. And in fact, just from a domestic standpoint, we've even seen differences when, there are counsel coming from the south of India versus counsel coming from the north, and arbitrators also from different jurisdictions in India. So the approach that they have in terms of, how counsel should be approaching them, what is their posturing, how much they can engage with the other side, all of that is also different. So from even within the domestic jurisdiction, there are multiple factors that need to be taken into account when you're doing arbitrations, with multiple parties from various different places. So, Sapna, I think just in terms of, your last thoughts on this, I just have to ask two things. Firstly, you've given us a great sense of, how counsel should be prepared going into, the first case management conference. As young arbitrators, what is your recommendation to, practitioners getting into arbitration? How they should be tailoring their procedural orders? Are there any guidelines that they can look at? Of course, they can check with senior arbitrators as well. But what have been your tips? How did you manage to make your first standard PO1?
Oh, that's a great question. I begged, borrowed, and stole, I guess, if we're honest, but picked up, looked at procedural orders, Procedural Order Number 1 templates from the cases I had been involved in, and adapted and then added in thoughts based on my own experiences and things that could go wrong. And often I'll be involved in a case and I'll see something interesting and I'll think, okay, I want that in my standard PO1. I thought that the proposal in my London-seated case about witness statements was actually quite useful because it meant that the witness evidence was really focused on the witness's recollection rather than being a piece of advocacy. So I think you keep learning, keep incorporating, keep developing, keep tweaking. But it is good to have a standard to start with, and you can be inspired for that from procedural orders in your existing cases. Absolutely. And I do think also, just as a general tip for junior arbitrators, it's really hard, your first few cases. If I look back to my first few cases, they were when I was based in Dubai. I was fairly young at the time, but I had studied international arbitration and I was very interested in it. And at that time, Dubai did actually not have that many arbitration lawyers. I know it seems surprising now because it's thriving and there's loads of great arbitration lawyers at this time. But at that time, over, about 18, 19 years ago, there weren't. And the kinds of cases I would get would be often represented by counsel who knew nothing about arbitration. Quite often there would be a non-participating respondent, which adds additional obligations and responsibilities on the tribunal. So I had some really, really hard cases. And the way I got through it was to call a friend. I was really lucky to have mentors who were very experienced, and I was a bit shy at first about asking them questions, but I felt that sometimes it's very lonely being a sole arbitrator, particularly with difficult cases. And I found myself in certain cases where I really felt I had no option but to call up and pick someone's brains, obviously on an anonymous basis without breaching any confidentiality of the arbitration. And I received tremendously helpful advice. So my advice to junior arbitrators is beg, borrow, and steal, and don't be afraid to ask those who are more senior than you. I expect that they will very generously guide and advise you.
And that's lovely. Thank you. And
I time questions. Yes, I have one question for you, Sapna, which has actually been plaguing me. It's a bit academic because I have not faced a practical situation. Now, I'm talking about the recent Swedish judgment on the Neurovive matter where a procedural order, it was a detailed procedural order, and the parties challenged that there was a deviation from the procedural order by the arbitrator without giving notice to the party, and that would amount to a certain violation of natural justice. It's a Swedish High Court judgment. It has recently come up. And the recent, not that recent, but the English High Court judgment on that ZCCM investments, where basically the court had to deal with the issue that whether a procedural order amounts to an award under Section 68. What would be the ambits of it? Obviously, somebody challenged what was a procedural order, and they said that the word is because award is not defined under the New York Convention or under the English Arbitration Act. So this is just from my, because you had sat as an arbitrator in these diverse arbitration panels. Do you keep these factors in mind sometimes that, even if you are doing a procedural order, not necessarily a PO1, but something on a procedural that it might have a ramification that it might be challenged as an award under Section 68 of your English Arbitration Act? So you are, very specific in terms of coining terms, in terms of ruling, procedural, so that it can't be interpreted otherwise?
That is a great question. I do recall being involved in an English-seated case where there was an important discussion about whether our interim award would be construed as an award under the English Arbitration Act. I cannot recall where we landed on that. But I think that as an arbitrator, you have to assume that any procedural decision you make could be scrutinized at some stage and may possibly be a ground in due course for setting aside the award for a procedural irregularity or breach of natural justice or whatever the specific set-aside criteria are in the jurisdiction in which the arbitration is seated. And I think it's just very important to be very clear what the procedural rules say about how you determine the procedure. They usually say something like the arbitral tribunal is free to determine the procedure after consulting the parties as long as the arbitration is conducted effectively, expeditiously, fairly, etc. And I think that whatever the applicable criterion is on that arbitration, that should always be your guiding light. And frankly, for example, in the SIAC rules and the old rules, it was Rule 19.1, your procedural discretion, but also your procedural duty as to how you make procedural decisions, what the benchmarks are in terms of fairness, expedition, etc. And I think practically every procedural decision I make, I'll mention 19.1 and I'll consider it very actively. So I don't know if that answers your question, but I think one should always assume that one's decisions, even procedural decisions, not just substantive decisions, may be subject to scrutiny at some point, and you make sure that you're complying with your duties within the applicable framework of the arbitration.
Thank you, Sapna. Thanks, Sudeshna. do realize that we are coming to the end of this podcast, and we could go on. I'm sure we could go on for an hour more, but this is bringing us to a lovely end where we've discussed great things about Procedural Order 1. In fact, this is something that's really not touched upon. I'm super glad that we could have Sapna. You come in with your experience and talk about Procedural Order. Thank you, Sudeshna, for your lovely inputs. And again, thank you so much on behalf of the ICC also to sort of come in and make time for this. It was a great discussion, and I'm super happy that we could all be here and talk about this. Thank you.
Thank you so much. It was such a pleasure for me. And Sudeshna, I really enjoyed hearing your perspectives, particularly on Indian domestic arbitration, which I have a little experience of. But yeah, very, very interesting to compare notes. Thank you very much indeed again for inviting me.